So generally speaking, once a lease is signed between a landlord and a tenant, the parties are locked into an agreement. But did you know there are multiple mechanisms for tenants to simply say, I'm done and I owe you nothing? We're talking about that today. Let's get started. Your lease is a pretty good indication of what your tenant is ultimately going to pay you over time for the opportunity to stay on rental premises. Today, I'm going to talk about provisions that are found in the Texas Property Code that actually allow a tenant to terminate their lease well ahead of schedule if you, as the landlord, fail to comply with the law. Now, while I'm speaking out of the Texas Property Code and don't have time to go through every single state, nor am I licensed in every state to speak about those with any kind of intelligence, I can say that many states across the United States have similar laws in their books. So if you have a situation similar to any of the following 14 reasons that a tenant can terminate a lease in the state of Texas, you may want to look into local law to see if any of these is cause for your tenant to simply walk on your lease. Section 92.0081 of the Texas Property Code says that a tenant who is wrongfully withheld from being able to enter property can, on their own, simply terminate their lease and walk away from their lease without any additional obligation to their landlord. In the past, many landlords used this self-help remedy of simply saying, get out, or while a tenant was out, they gathered all their things, put it on the porch, and changed the locks. This is 100% wrong. And it doesn't even matter that the residential lease allows you to do this. I've had landlords ask me, is it legal for me to have a provision in my lease that says if ever you are in default for more than X amount of days or X number of months, I can simply remove you from the property without judicial process? And the short answer is no, and 92.0081 proves that. If a tenant is not given judicial notice of a judicial proceeding and an order signed by a judge, you simply do not have the authority to remove them or exclude them from your rental property. Do you know whether or not your property lies in a floodplain? Depending on where you are in the United States of America, you may have certain natural disasters that are prone to occur in certain parts of your state. In Texas, the state legislature has recently changed the law to allow a tenant to terminate a lease if they've experienced a substantial loss after a flood when their landlord failed to warn them of the danger of being located in a floodplain. If you have a property that is located in a floodplain, you have an obligation to mention that to your tenant. And if you don't, they have the right to simply terminate their lease and walk away if they've experienced a substantial enough loss, even if the property is not otherwise rendered uninhabitable. It has everything to do with their loss, and it doesn't matter that they're insured. If they suffer this loss because you failed to disclose that your property was in a floodplain, they can walk. Landlords, I know you're getting a lot of great information, possibly stuff you've never heard of before. If you're enjoying what you hear today, give us a like. Thank you so much for all of your support. All right, so the next 4 categories have to do with certain life events that pop up from time to time that have been on the books for a while and that all landlords need to be aware of. Now, each of these have different requirements and only kick in when certain additional documentation is given. I'm not going to go deep into the description of each, but I do want to talk about the following 4 ways that a tenant can otherwise terminate their lease, even in the middle of a lease term. The first one has to do with certain instances of family violence. Now, in the state of Texas, and this is true in many states, the definition of family violence is pretty broad, and it does not require that people actually be married or that they actually be blood relatives. If they are in a family situation, and you want to consult your own state law for that determination, but basically if you have a family situation where violence occurs, one of the parties can say, I am out of here because I'm otherwise in danger. And so if the tenant has shown what this particular section in the property code, which is 92.016, if they show all of the requirements that are there to you, the landlord, they can simply terminate their lease with you. Additionally, there are other crimes that come into play, particularly those having to do with certain sex offenses or even stalking. In these instances, when a tenant can show that they have a restraining order or some kind of legal mechanism that prevents somebody or that indicates that they are in danger from the acts of a third party based on where they live, and that they have demonstrated to you that continuing to stay on the premises continues to put them in this danger, these people also can simply terminate their lease without any additional consequences once they have actually vacated. The next has to do with military service. If someone is a member of the military and they are deployed in such a way that requires them to move, and this includes their family members, can simply terminate the lease and move on. Now, they, again, like the other provisions, do have to show certain documentation to you that, in fact, confirms that the reason they're moving is due to active duty deployment. Now, this provision is found in Chapter 92.017. And the last one, found in Chapter 92.0162, has to do with the death of a tenant. If a tenant has died and only an occupant remains, that occupant can simply say, look, I'm no longer going to live here. This sometimes happens when minor children are left. Of course, the minor children are not going to be obligated under the lease. Perhaps a disabled person is left, and now they have to go into the care of some other party. Once the original tenant, who was the only tenant on the lease, has passed away, of course, no continuing obligation there for them or the family. The lease can simply be terminated after, again, certain procedures are followed by the family members. In the state of Texas, when a given property has suffered a casualty loss due to some casualty event, flood, fire, wind, once a property is damaged to the point that the entire property, or pretty much the entire property, is deemed uninhabitable, the tenant can simply walk away. You are not required as a landlord to put them up until the house is put back. You can, and you can potentially keep that tenant if, in fact, the repair happens quickly. It's possible to simply put them up in some alternative spot, fix the unit, get them back in like nothing happened. However, it's not usually that easy. If an entire place is rendered uninhabitable, the repair could take weeks, sometimes months to complete, and it's just not practical to keep a lease like this going. And so in this situation, the landlord or the tenant can terminate with a written notice to the other side, and again, no continuing obligations after that. Now, issues with repair come up a lot. And so if it happens that your tenant has requested a repair from a defect on the premises that materially affects the health or safety of an ordinary tenant, you've got an obligation to complete that repair. And if, as a landlord, you fail in your duty for whatever reason, if you fail in your duty and have not acted with reasonable diligence, the tenant can issue you a written notice saying, as of date X, due to the failure to get this repair completed, because this defect continues to affect my health and or safety, the tenant can leave. And so it's a common one where tenants will threaten this provision of the property code or this provision that's in their lease. But remember, the terms are important here. This would have to be a defect on the premises that materially affects health and safety. The fact that it kind of affects or might affect someone's health or safety is not enough. There has to be a material effect. Now, you may be asking, Ernie, well, how do we determine if some effect is material or not. Well, unfortunately, there's no good definition in the law itself. These are the kinds of determinations that are made by a court. And so if you have a situation like this, you'll want to discuss this with your attorney. If you're in Texas, I'm happy to review these facts with you to make that determination and let you know whether or not, in my legal opinion, the facts that you present amount to what the court would also likely see as a material effect on a person's health or safety. It's in these situations where a landlord is obligated to act with diligence, and if they fail to, where a tenant can simply hand a notice and say, I am terminating this lease based on this defect. All right, so the next three have to do with security devices. 92.164, 165, and 168 are interconnected, and I want to talk about these three provisions together. The first one has to do with the landlord's failure to rekey a unit after a prior tenant has moved out. State law in the state of Texas, and again in many other states, requires that a landlord change the locks so that a tenant is protected from the possibility that a prior tenant still holds a key and can enter at any time into the dwelling. If the tenant has requested this change and the landlord has refused to do it, the tenant can simply terminate the lease and walk away. Texas Property Code 92.165 is similar. It describes a landlord's failure to make repairs to a certain security device found on the property that's not necessarily rekeying, could be other security devices that are on the premises that the landlord has an obligation to repair or replace. It describes the fact that a tenant has given reasonable notice and that the landlord has failed, or if the landlord fails to respond to this reasonable notice, that the tenant, again, has the right to simply submit a notice of termination and walk away from any future obligations on the lease. 92.168 allows a tenant to terminate their lease for violations of 92.164 and 92.165, even when there is a management company in place. So it doesn't matter that the owner themselves has failed to address these issues. If a management company has simply said, nope, can't do it, can't do it, can't do it, 92.168 allows the tenant to terminate the lease on the representations made by the management company, even if the owner was perfectly fine with it. If the management company has said no on the owner's behalf, that serves as a legal basis for the tenant to terminate. In the state of Texas and in a number of other states, it is not legal for the landlord to fail to disclose who they are and how they can be contacted. If a tenant requests this information, either from the landlord themselves or from their property manager, and the landlord, owner of the property, fails to disclose the following information, the tenant can unilaterally terminate their lease. Under Texas Property Code 92.201, a tenant is allowed to ask who the owner is, i.e. what is their name, either an individual or an entity, and how can they be contacted through their mailing address or post office box. If this information is requested, the landlord has 7 days to get it to the tenant after that written request is made. If the tenant doesn't get it and the landlord has not sent it, tenant can terminate. 92.205 says that the tenant can either take you to court and have the court force you to give that information, or they can just leave. One of their options is unilateral termination. It's a drastic measure, but I've seen it happen where tenants who are either not happy with what's going on, they'll ask for this information, the landlord will not give it or not pay any attention to it, and on day 8 the tenant says, oh yeah, well I'm leaving, and it's a simple way for tenants to simply terminate a lease when the landlord fails to follow the law. Texas Property Code 92.260 has everything to do with smoke alarms, and fire extinguishers. And if a landlord is requested by their tenant to come and check either of these and the landlord simply doesn't do it, or if the tenant informs the landlord that either the smoke alarm or the fire extinguisher are inoperable and need to be repaired or replaced, and the landlord does nothing about it, you guessed it, the tenant has every right to send a written notice to the landlord saying, we are done. So whenever a landlord is unaware of these provisions of the Texas Property Code, it's very easy for a tenant to do a simple Google search and find out what are my remedies for my landlord not repairing the smoke alarm, or not installing a smoke alarm properly, or not providing a fire extinguisher. Again, the tenant has these rights to ask for these things, and if you straight deny them, this remedy is available. They can simply terminate that lease. Finally, Chapter 92.301 has to do with an illegal utility shutoff. It is possible in the state of Texas for someone's utilities to be shut off. If you don't know the legal way to do this, don't try it on your own, because aside from the tenant being able, you guessed it, to terminate that lease, there's a whole host of other remedies that are available to the tenant where they can get economic damages from you for that illegal shutoff. If you are supplying electricity to your tenant, make sure you know your rights, duties, and obligations before you go tinkering around with those utilities. If you are not supplying the utilities, you have even less of a basis for any kind of shutoff, and you simply shouldn't interfere with your tenant's utilities. Again, aside from their right to simply terminate the lease, they can come after you for legal costs, economic harm, and civil penalties under the property code. Illegal utility shutoff, never, ever, ever a good idea. Unfortunately, when we don't know the law, it's difficult for us to follow the law. You may find yourself with all sorts of questions based on what you saw today. If you are in Texas and need some legal advice, we are open all the time to your questions and comments. You can leave those here. You can give us a call or shoot us an email. We're happy to discuss your case and the facts of your matter with you specifically. So the flip side to tenants who simply want to pack up and get out of town as quickly as possible are those tenants who simply won't leave, particularly the ones who never signed a contract, who you don't know. We call these people serial squatters. And if you want to know a little bit more about them, there's a video right here. I welcome you to check it out. And until next time, landlords, happy leasing.